been here Wednesday, Thursday, and Friday, and today I'm with Gabby. She's from our office. Hi, everyone. Hi. And we are here today. We're going to start the session talking about marriage fraud. We're going to talk about investigation. We're going to be talking about fraud investigation and how AI is playing into it. There's a lot of things that this conference has shed light on that we did not know. And there's some concerning news. One of it, which is that we just had the former USCIS officer director, as well as the former USCIS Service Center director, who no longer serves at USCIS, and they were sharing about how the hiring has changed. Right now, with USCIS, for a lot of entry-level positions, college degrees no longer required, plus there's a 50,000 sign-in bonus. It's a great time to apply to serve at USCIS. There's no doubt, and I think it is a very important agency, and I hope everybody who's qualified does apply. The second thing that I'm much more concerned about is that almost half of the executive staff, 50% of the executive staff at USCIS at senior level positions since last year have left. 73, I think, plus positions vacated. Any agency of that size does not have the bandwidth and ability to level up people at that level quickly. If it was just a few, maybe they could be elevated. But because they don't, and because they can't, the alternative is political appointments. So suddenly, within just a short period, 50% of the executive team at USCIS, the government agency that adjudicates immigration, they are being politically assigned to administer the policy of immigration according to this political climate. That is a very concerning situation. And we're not even getting into fraud yet. Fraud detection, deputized, and they have a lot of police authority. That is all impacting marriage interviews as well as all the memos. So we've been discussing a lot of that. Gabby has a lot to share because she's done thousands of these cases now, and especially since the last year. But I already see a lot of questions coming in, so we'll address some questions first before we get to what we're going to talk about regarding fraud.
Any info on DS removal? How's that going to affect F1 students?
That is huge, and you know what? Since you asked that question, I wasn't quite certain about what I was going to address next after, because this first half an hour we're going to address this fraud thing, but the second half of this live conference, we're going to talk about F1 original status, and there are big updates that I want to share. So stick around. In a bit, I'll definitely talk. I'll spend the entire second portion talking about that. How about that? That's a promise. Okay.
Okay, we'll get back into the fraud then.
Okay, quickly go back into fraud. So, what are you seeing at Stokes interviews, right? Like clients being called to interviews. Is it the worst cases that have these Stokes interviews, or good cases have Stokes interviews too?
Surprisingly not bad cases only. All the really good cases too. Even people that have children. Before, if you had a child, it's considered, okay, you don't need a lot of quantified documents to prove your relationship because you already have a child. But it turns out having a child is not enough to prove that you're in a legitimate marriage anymore.
Wow.
So they consider that to be, non-relevant information, and now they still can. It's crazy,
Yeah,
right?
yeah.
How can you think you have a child with someone, but you're not in a legitimate relationship with them?
Right.
So, so they still separate the spouses. There was a lady that was 8 months pregnant. She went into the interview. She couldn't really move. She was already getting ready to give birth. And the officer said, no, you still have to be separated. Go wait outside. So that makes the interview a lot longer, right? Like when you have to first take the husband and the wife, it prolongs everything. And the officer was like, no, we still need to do it. They were like, oh, she's about to give birth.
Yeah.
So it seems to be now that even good cases are going to be undergoing fraud investigation. And it's because of the new policies and the government and how everything is, developing with USCIS. So be ready for a lot of the stock interviews, and I guess prepared for your clients for stock interviews.
Right. How can someone prepare for one of those difficult marriage separation interviews? Right. How do we do it? How have you been doing with our clients? Because a lot of people go, well, my marriage is real. Everybody just focuses on my marriage is real.
Right.
How do you actually prepare to demonstrate that it's real? Right? What is the coaching methods?
So I think the best way to prepare for these stocks interviews is just anticipating the stocks interview, right? Like, so not thinking that it's going to be a normal interview and then just giving them tips and having them provide even more proof. Not only like children that are born to the marriage, but how long they have been dating. Doing the mock interviews, I think it helps a lot. And like attorney clean ISO. So you do that, and then it's like, okay, well, now ask the questions and see what the response is. Or sometimes you can use different techniques. You can do the stocks interview with both the spouses in the room to see who answers what, and then to see what the contradicting information maybe. We have some questions.
Yeah, is this marriage cases or other family cases as well?
Marriage based.
Only
Marriage-based
marriage
cases are the ones that they focus more most on. We have been still seeing interviews waived, right?
Yes, a lot of
So-
approvals without interviews.
Parents, children.
Parents, yeah, correct. Children petitioning for parents, parents petitioning for children, the step parents petitioning for stepchildren are also being waived, but not marriage based. I think most marriage based cases are still going through the process of interview, and now the interviews are. It seems like the officers now have more time to investigate into these marriages because they don't have to interview the rest of the cases, right? So they waive the other interviews to make room to do these like really difficult marriage-based interviews.
But it's not necessary. The parent sibling petitions, they can still have interviews. And business cases can still have interviews, right? EB5 cases, EB1 cases. Traditionally, a lot of business cases were interview waived, but now a lot of them still can have it, and we've seen, and it can happen multiple times. Like an applicant can have 3 interviews before the final adjudication. So we've seen all of that. But today's main thing, fraud detection units being sent to investigate somebody's home, some people's work, knocking on doors. They're no longer just a contractor just taking notes. Oh, where's your toothbrush? Oh, where's your sock drawer, right? I want to see that both of you have like the same, things in the same room, right? But now it's much more they're deputized, so they have police authority to do arrests, to do detains, and to report the ICE. There's a lot of things that USCIS fraud detection unit now have, and they can do it in parallel. So in the past, again, USCIS interview, if it goes awry, if there's suspicion, then they hand it over to fraud detection. But now, fraud detection can actually start first, investigate, and then hand over the notes to the interviewing officer. And right at the interview, if it doesn't go well, then it's being detained. So things have been flipped, so there's a lot to prepare for that.
I'm having a slight issue with the last step of the CFO process with my wife. Do you guys know about that and how to ask a question?
What's a CFO? Yeah.
CFO process?
Yeah, clarify what the CFO process is. Yeah.
Okay. If I entered the US with a B1, B2, and an expired green card, it expired in 2018, and I sign my I-407 with CBP, can I then apply for LPR again via my US citizen son?
Yes.
And how soon will that be a negative factor for me?
Not a negative factor.
Not a negative factor.
Yeah, so we've done several cases that are just like this. So obviously you had a green card, it expired, you abandoned it, you legitimately applied for a tourist visa, you came in as a tourist visa, all good, all above board, wonderful. Now you want to apply for a green card again, not a problem. You go through the exact same steps. There's not going to be a problem at the I-130 stage. There's not going to be a problem at the NBC stage, and then you're going to go to the consulate. There's not going to be a problem there. If you do adjustment status, there might be additional things, but that's because of adjustment status. It's just kind of crazy these days. But the fact that you were a green card holder, you abandoned and you're reapplying is not a negative factor that have caused significant denials. However, they do want to make sure that you're paying your exit tax with the IRS. Did you abandon your green card? But are there other things that cause you to be inadmissible or deportable, right? So those are different standards now. As a new person trying to become a just, old criminal records that wasn't a problem before when you first got it, could be a problem now. So those are things to kind of resurface. But if all else is clean, all things are good, taxes are good. If your child petitions you and it's clean, you can still get it, right?
Right. Yes.
So I have a clean record, but what are the chances that even though I have the tourist visa, what are the chances ICE detains me? I'll be turned over to ICE and I'll get detained.
Okay, so this is the same question.
Yes.
Same person?
Yeah.
Okay. So therefore, I'm assuming you came in as a tourist visa, and now you want to apply for adjustment of status.
I think they're thinking about coming in as a tourist visa.
Oh, you're thinking about coming in as a tourist, and then immediately within 90 days or so, apply for adjustment of status, right? Right.
Mm-hmm.
Okay. Well, in that case, your situation is nearly similar to everyone else with tourist visa and then applying for adjustment of status. You really need to take a good look at the adjustment of status memo that just came out on May 21st. Look at some of the in-depth video discussions that we've had on it. You really should be able to prove why you're doing this, as opposed to winning your home country, right? Because that's one of the first things the officer is going to ask you. It's not impossible, but the May 21st memo is much more concerning for your case as opposed to your prior LPR case.
Mm. My husband filed from schizophrenia and filed false case against me. What should I do now?
I don't know how that relates to the immigration context. It depends on where you are in the immigration. Are you already a green card holder and you're becoming a citizen? Are you already a citizen? Is your husband a non-citizen? It depends on your situation exactly. Are you a student, right?
They're a 10-year green card holder.
They are a 10-year green card holder, and you are.
I assume the commenter is a 10-year green card holder,
Okay.
and their spouse is a U.S. citizen. That's just what I assume.
Okay. And they filed a what?
False case against the person.
Okay. Well, yeah. When you're applying for I-90 green card renewal, criminal record is the most important thing. So if you don't have that, should be okay. Assuming there's no other problems. If there is a conviction, which, I mean, if it's just a false claim and you're battling it out, you could be able to explain that, and potentially your 10-year green card can still be renewed. The same logic completely applies for the N400. So you are completely separated from your husband, but whatever false claim, that's going to weave its way through the judicial system. But if it's just like an accusation, officer might look into that, but do your best to explain and prove your innocence.
Okay, so CFO is the Commission on Filipinos Overseas. So the question is, my wife is currently in the Commission on Filipinos Overseas process in the Philippines for her immigrant visa. But the CFO requested my FBI record. And while gathering my documents, I discovered that my I-130 only listed my current marriage and omitted a prior marriage that was terminated legally. So I have the divorce records in order to certified copy, but I'm still having a hang-up. Should I proactively correct this with USCIS? Because, yeah, their record doesn't include a previous marriage.
Would you say a refile? A withdrawal and a refile?
But it's an I-130. Well, yeah, so here, that's a good one. If it's a pending I-130, amendment would be great because it hasn't been adjudicated yet. So you have an opportunity to supplement. If the I-130 has already been approved and it's been a long, long time, again, you could try to file an amendment, but it's going to take a little bit longer, right? And you have to wait, and it becomes, you're going to stuck in limbo. I-130 is just a preliminary step. It's not the final step yet, right? Because you still have to go to National Visa Center, you still have to go to the concept process, and during the DS-260 stage or the 45 stage, you can supplement a lot more information. Of course, they might question, they might challenge, but you didn't actually get any immigration benefits, so it might not be fraud and misrepresentation. So I think in the past, it would be pretty easy just to correct it at the later stages because it's a prior marriage. But because in the Philippines, they don't recognize divorce, and so there's a lot of questions regarding that at the consulate and at the adjustment status stage. So if you don't correct it, you're gonna have to explain it. If you do correct it, you're probably still gonna have to explain it anyways. But I guess if it's pending, I would for sure file the amendment. If it's already approved and you are already well along into your NVC adjustment status stage.
Yeah, they said there's the last step of the process.
The last step of the process, I would probably just prepare everything and explain it.
Just at the clarification. My green card is active till next year. I got the green card after tourist visa AOS. Got it last year. Hold on. Where's the rest of this question? Okay. Conditional green card
Okay.
via marriage and Iran passport. I need to make a short international trip. Will that be an issue?
The conditional green card.
Conditional green card.
Got it from tourist AOS.
You came in as a tourist. You filed for adjustment of status. You got a conditional green card, meaning you married a U.S. citizen. You got it. This is not like a short, one-step thing. It probably took you years, 3 years, 4 years to get it, and so it's been a significantly long time. You have a long history in the U.S. If you're traveling and coming back in, if your question is, can somebody who has an Iran passport but a green card holder, can they travel and enter? The answer is yes. CBP will probably put you secondary, ask you a few questions. So that itself is not the problem. If your concern is more so, if your question is more so because tourists to adjustment status is a big concern now, that's how you got it years ago. Will that be a concern to customs now? And my answer is most likely not. Officers care about what status you are now. They have when they see you, they have less than 2 minutes, and a lot of times less than 30 seconds to question you, to talk to you. And so if you give them a good reason to admit you, right? Your vacation abroad is just 3 days. It's just 3 weeks. It's a short. You're working in the U.S. You have other security clearances. You've been global. You have your global entry, right? You have all these other things that validates you. And this was just a short temporary visit abroad, innocent. Most likely that 30 seconds, 1 minute should be fine. But if you're saying, I got my 10-year conditional green card, but I'm leaving for a year and a half, with or without a reentry permit, your husband is here or your wife is here, then an officer can start piecing everything together. How did you get your green card? Is your marriage still real, right? And they might go kind of validate all these things. But again, nobody would recommend you to travel given the state of affairs, global affairs. But because you have a lawful permanent residency, that green card is your validity to enter the U.S. If airlines don't accept you, you can try to do it at the border, and they will review that. But the moment there's an executive order bans, any Iranian nationals from entering or leaving the U.S., then you might be stuck. So again, definitely be careful.
Okay, so following up on this schizophrenic issue where the husband filed a false claim. So the husband had actually started a consular report of birth abroad for their daughter born in Ghana, but due to this mental illness, they couldn't finish the CRBA. What should they do?
I don't know. Yeah. I think we want to look more into that case specifically. What did they do? How did they do it? What's the last step? What can still be done? Consular births are tedious, it's long, but if you succeed, then they become a citizen, right? So it's pretty important. Now, if you are a green card holder, and if it's consular birth, if you're still abroad, you can look into the NA3. Maybe you can still get your kid a green card and come back to the U.S. really quickly. And then if you naturalize, then they could do the N600K and then they become a citizen, right? So look into other pathways, but consular birth, it's a one-step, easiest thing. Try to do that. If you can't, then it might have to fall on you.
Does consular birth have to be done within the first 12 months of the child's life? So before they turn 1 year old?
I don't remember. I haven't done consular birth in a long time.
I think that would be something to look into as well. Like if there is a timeline and the child needs to be under a certain age.
NA3 is first time entering with a child under 2 years old. So depends how old the child, depends where you are in the world, and depends on if you're going to pass on your green card status to your kid.
So it only applies to the mother, not the father.
Right.
Hi, Yogesh. Did the conference, has AILA talked about political environments or any key themes that have come up?
One of the big things I just mentioned right now, I didn't know almost 50% of the executive directors at USCIS left. And and now they are being politically appointed, meaning they have political agendas, meaning they might not have the USCIS understanding and processing history to be able to administer this agency. So if the top heads of USCIS and a majority of them have an agenda to change a benefit agency to a vetting agency to really implement fraud and detection without the proper understanding of how an application, motion to reopen, reconsider, the use of AI, if they don't have a sophisticated understanding of the USCIS model, a lot of cases could be incorrectly denied. A lot of cases can be incorrectly adjudicated and have severe consequences. Because if USCIS makes a decision, passes over to ICE passes over to immigration court, people's lives can be stuck in limbo. People can get stuck in detention, all due to errors. And when that happens, real people suffer. And litigation might be the only way to kind of correct the problems here. So that was news to me, and I'm extremely shocked and distraught by that because I was hoping USCIS could be better than that.
So I'm a U.S. citizen. I filed for my wife, who's in Ethiopia, which is on one of these 75 country bans. Yeah. It's been 17 months. Haven't heard anything. What should I do? What can I do?
If they are banned to get an immigrant visa, if you can, and I know it's a super far stretch, H-1B, L-1 visas are dual intent. If she can get that, then she can come into the country with a visa, and then you can do adjustment status here to get around the 75 country ban. I know it's a tall order, and I know you might not know when the 75 country ban will be lifted. It could be next week. It could also be 2 years from now. So, if it's possible, and this means is acceptable, that is what we're going to do.
Would you say it's recommended to also do a B1, B2 and then try to do adjustment, or you think that's too risky right
That's
now?
too hard. I think the success rate is probably under 2%, if not even lower than that, right? If you have an immigrant petition, B1, B2 from a 75 country ban, extremely difficult. Now, if you have a really urgent humanitarian explanation to be able to do it, that's possible. But then it makes your adjustment status just that much harder later on as well. So it's a step-by-step process. It's quite hard. Yeah.
What do you do if you won asylum in a ICE custody, still denied? What can you do?
We don't do asylum cases, so I'm really not in the best position to answer that. Definitely consult an asylum specialist.
When you were talking about Stokes' interview separation, and home visits with the fraud unit, is that specific to marriage cases? Like other family cases are normal?
Well, fraud detection could be for any application. Stokes interview generally is for marriage cases, and that's where we see them most used. But it is entirely possible during a family case. So, for example, let's say you're applying for adjustment of status, and it's a family of three: you, your spouse, and your kid. And all three are applying for adjustment of status, 3 separate 45 interviews. And the principal applicant could be a business case. Doesn't matter, right? ED1A, any other category. In that 3 separate applications could be 3 separate interviews, and 3 separate interviews therefore could be like 3 Stokes interviews in a sense, right? They ask you one question, they ask your spouse another question, they ask your kids another question, and suddenly, hey, the 3 answers don't quite match up. You all came in as a tourist, but then now you all filed adjustment. Was that originally the plan? Was there fraud and misrepresentation? Who committed the fraud? And now suddenly 2 people have to apply for waivers, right? So these are things to kind of think about.
So I want to talk about some ways to help your case move along, right? Yogesh is asking, does InfoPass work? You speak to an officer. Does Congress or Senator support help? Does Ombudsman Service help? Like, what are the best ways?
So, this is hearsay, but from Ombudsman, I hear that they are just passing along the inquiry. So, Ombudsman's help is now going to be significantly more limited compared to the past. Senators, congressmen, they do help, right? When you are able to go to them and they send that inquiry in, a lot of times USCIS responds and then they get on it a little bit faster. So that definitely could work. InfoPass, Emma, could they could work, right? And we've done a lot of these. It's a shot in the dark, but you might as well try, right? The other day we were able to help a client get an emergency advance parole within 1 day, right? They just went in, got it in 1 day. And we haven't seen that done in years. We were able to get a case motion to reopen approved without filing a 290B at the local office. So you directly talking to a USCIS officer, they have a lot of power to be able to do things immediately for you. So in person, one-on-one conversations might be the way to go to expedite these things. Now, congressional support definitely adds a layer of inquiry into it, for sure.
What about you, Gabby? What have you
What
seen?
about expediter requests?
Yeah.
Do you think that's still possible to file if you have like a humanitarian reason or if you have financial hardship?
So the way we did it for a lot of the other cases, file the expedite request, make the info pass, go talk to them, and present all documents, right? So you did it the right way. You didn't just show up and say, I have an emergency, because everyone does that.
You tried everything else first
Yeah,
in order to show them.
You filed it, you paid the fee, you went through the info pass, you got an appointment, you waited by the phone, and then you presented a package, you prepared the primary documents. They're not just relying on your word of mouth, right? You did everything possible. And so that's how we were able to do it in the past few months to get these emergency events rules, to get these work permits, to get these things. Now, if all that doesn't work, then mandamus, right? Mandamus is super government.
I was approved at the office for a green card. 10 months later, I've received nothing. Thoughts? What should I do?
3 months, I think, is
10 months. 10 months.
I know. 3 months is acceptable. 10 months is getting a little bit long. I think by the 12 months mark, definitely start doing a lot of inquiries. And we've seen a case that's taken over 15 months after the interview. And I was telling them then I think that the time for the mandamus might be 1.5 years. So they're gearing up for it.
How do you prove bias, like judicial bias or enforcement bias?
How do you prove it? How do you prove that the other party had it and they misjudged your case in error and we had an adverse decision and it's due to bias and not due to an approvable case, right? It was a good question. I actually taught this course when I was part of the DIA committee for AILA. This is where having an attorney at the interview actually makes a difference. It's rare, but it happens. An officer goes off script and starts asking things that they shouldn't quite ask. They start commenting things. They start saying things that they really shouldn't have said. And when they say certain things, it shows their internal intent. And when they conduct themselves that way, an attorney at the interview can stop the interview, can ask for a supervisor. And when that happens, the supervisor comes out, the attorney says, hey, look, I've been here. I've been taking notes. This is what happened. This is what transpired. And I believe there's a prejudice that has seeped into this interview. Our client is this kind of application. It seems good on paper. It has all these things. But the interview has gone script, and I believe prejudice is playing a role. I request a different officer, or I request withdrawal case and refile, or I request the supervisor you kind of step in and adjudicate. This happened to some of our cases,
right,
where there was an interview or a request for evidence, a denial. We did a motion to reopen, a second interview, maybe even a third interview, a request for evidence, and the officer was just blazingly annoyed and intent to deny the case. But we got the supervisor involved and we got the case approved, right? This was their case. We did it together. Market was involved, heavily worked on it. It was really, really hard. And honestly, it was a bad case. It was a weak case, not bad. It was a really weak case. Like if you wanted us to grade, like super approvable 10 out of 10, super weak 1 out of 10, I would probably put this where 2 or 3, under 4.
2.5.
Yeah, under 4.
Yeah,
right? It was like a 2 or
definitely
3.
under 4.
It was a weak case, so we understand the officer's discretion to deny the case, to call back the interview multiple times. But during that line of questioning, so much prejudice came out, and that's not professional. That's not acceptable. And the supervisor came in and said, you were not the first person to bring this to my attention. This officer has done this repeatedly. And so because of the bad history of the officer, because of good history of our reputation in representing clients, the officer stepped in and approved the case that was actually weak. And, I mean, you could call it luck. You could call it the client not giving up. But it's one of those things where bias had to be proved beyond a reasonable doubt.
Just can you do me a favor and move this mic up?
This one?
Yeah, closer to your mouth. Okay, good. And Gabby, we are halfway through.
Okay.
How are you feeling?
I'm ready to go.
You're ready to go?
Thank
Okay.
you, Gabby. Thank you. All right.
And I will take your microphones.
Yes.
So I'm filing an EB2 NIW
Yes.
as an international student from Gabon. Do you think I'm at risk to be denied just because of my country of origin? And I just have a bachelor's of science.
Well, here's something that's really scary, completely surprising. Did not expect this. An I-140 EB2 was filed for one of our clients as well. They were on E2 status, and just because by the virtue of the I-140 application, the E2 was revoked. We've never seen that happen before. Never was a risk that we had to seriously consider. It was a risk if we filed it and the client had to leave the country to go to consulates, but to be revoked in the U.S., unheard of. Your situation, if you are in the U.S. and you file this, there is that small possibility that now when USCIS takes over student visas, student statuses, there might be a chance that you lose your student visa. Now, if you're saying it's okay, I'm already graduating, I'm ready to leave the country anyways, it doesn't matter. I'm filing the I-140, I'm filing for the NIW, and if I get approved, then I'll wait for the green card. If I don't get approved, I'll just improve my resume and I'll file again. Then maybe that's not a big concern. As far as your country, I think the biggest concern is what are you going to do for the U.S., right? The officers might have certain prejudices, right? Whatever field you are, they might say, well, the U.S. doesn't need that. So prove by preponderance of evidence, go above and beyond that the U.S. does need you, that your industry does need you, that you are going to contribute and you're going to do something amazing. You have contracts and you have things that really prove that your plan is of national interest. That is the key. Where a country you're from plays into that, it can work to your advantage, prove you're extraordinary, but it depends on what you're actually doing.
Will USCIS officers speak to you if you just turn up unannounced to a field office? How do I actually set up a one-on-one face-to-face meeting with them?
So InfoPass is the way to schedule the one-on-one meeting. But if you can't get that one-on-one meeting with InfoPass, you can try just to go and talk to an officer. I know it's crazy, and every field office does it differently. From what I've heard, DC office does not allow it. No attorneys have seen it work, and appearance attorneys have never seen it work. I was quite surprised by that because I've seen it work at Santa Ana office in LA. I've seen it with the District 43 in the LA Los Angeles office. I've seen it work at the Riverside, Ontario office. So I've seen it done in Southern California routinely, different administrations, without an appointment, preparing the case file, attorney going in, talking to an officer, clients going in, talking to an officer, officers understanding, adjudicating, and helping the client. And it must be a regional thing. I don't want to say the rest of the country can't do it. I think it's going to be up to each individual office and each individual officer.
So on this CFO Philippines issue, my wife already got the visa from the U.S. Embassy, right? They're in the last step. If there is an issue because of my lack of reporting of this prior marriage, will my wife's visa be revoked?
Possibly.
Okay, on this Stokes interview situation, is it possible for AOS interviews to separate the U.S. citizen sponsor and the immigrant applicant, or not possible in non-marriage cases?
Yeah.
How common would you say Stokes interviews are? Very low.
Yeah, I don't think I've seen or heard that happening. Yeah, like for example, sibling petitioning parent and then separating the two of them, right? Or parents petitioning children, or sibling petitioning sibling. I don't think I've seen a detailed Stokes interview for that. Fraud investigation is possible, but and you know what the idea is, because if it's a biological relationship, you have the birth certificate, you have DNA samples. That is the basis for the I-130, right? So Stokes' interview is trying to tease out whether or not that's real or not. But if you have DNA samples, if you have birth certificate, that is almost concrete proof. It's hard to fake that. Now, other things like stepchildren, okay, well that could be questionable, and so that's why there could be a detailed interview. But we've still seen those get approved even without an interview. You might say, well, that could be fraud too. I think it's just the political climate. Marriage fraud is such high on the radar that they really want to focus on it. That's why all the social do a lot of resources to it.
Tell me, how can a doctor get an immigrant visa to work in the U.S. in detail?
How can a doctor get an immigrant visa to work in the U.S.? The visa categories that come top of mind is EB1A, EB2 and IW. Doctors oftentimes are quite wealthy. You could do the EB5. I've heard in this conference, Trump card, the gold card, is being processed, and a lot of people have gotten it. But they also got requests for evidence, which blows my mind. Like that was the whole point, not to the EB5.
Wait,
so
what?
that is totally possible as well. EB2, normal EB2, having a hospital petition you for legal as well. If you want to do it faster, you could do an O1 to come in and just continuously renew it, and you'll be able to just be here 3 years at a time. Switching different titles, 3 years, 3 years. O1 is almost like a mini green card. You could do an E2, but those are not green cards, so they're not immigrant visas. But if your goal is just to live and work in the U.S., O1 and E2 are some things that are totally possible. So, a couple things for your reference.
I filed 751 joint petition, but I'm in a different state. I moved to a different state than my spouse for work. Call my wife every day, and I visit. So, how much of a problem is this?
A high problem, because USCIS will immediately see different addresses when you file, especially if on your application it didn't show the different address, but when they're doing a background check, a couple days, a day before, a couple minutes before the interview, and they suddenly see, hey, there's a discrepancy, or AI scrubs your location differently. They call you into an interview, and let's say you weren't forthright about it, and they ask you a few questions, and you didn't disclose it, that will really piss off the officer, and almost immediately there might be a Stokes interview afterwards. But if you explain it, then it becomes, okay, you're honest about it, but is your marriage real, right? This happens. It is, we live in a country where cost of living is so high that it requires double income, and maybe that's just a better thing for your marriage, to live in two separately, to build your financial life together. But prove them, argue them, and prepare for them.
Are you in San Diego?
I am in San Diego. This is, we're at the Marriott, and this is where the AILA conference is being held.
Okay, in this case of the CFO, and it's possible that the visa might be revoked due to a lack of reporting, because what they submitted didn't include. Yes. If that is the case, what's my best option to fix that issue? And could I reapply again if her visa does get revoked?
So, a couple scenarios. Visa might be denied, but you might be invited to file a 601 waiver, fraud and misrepresentation, right? And well, let me think. Okay, the I-130 was filled out by you. You are the petitioner, so you're the one who, quote unquote, committed fraud and misrepresentation. So, if she got denied for fraud and misrepresentation, it actually saves your butt in a way, in the sense of you can file 601 waiver to prove there's going to be extreme hardship. Waive that, and she can still come in. The worst situation would be the I-130 being revoked because of the error, and so now you can't even file a 601 waiver because the I-130, the basis for that waiver has now been invalidated, and now you have to refile an I-130, and you have to explain everything, and you have to go back to the interview again, and that could delay things a lot longer. I don't know which one is actually worse, actually. So, but with USCIS these days, I-130 they get extremely long time. Both possibilities could happen. My recommendation is the visa has already been approved. They're doing additional screening or whatnot. I would just start preparing for that waiver argument, for that explanation, and if asked and if challenged, you'll be able to present that. And whichever option they give you, you're ready to do it next day, basically, right?
So why not do like proactively kind of? I don't know. What are the options if they want to proactively tackle this?
The reason is you're guessing. And in this administration, there's so many things that could be a reason for the investigation. And if everyone tries to correct an error that they think is causing the delay, what do you think would be the processing time for every government agency? Every consulate, USCIS, it would double, it would triple, it would quadruple. What if they're investigating something that's completely irrelevant, and now you try to correct something that they've already approved, and now it becomes something that they now have to deny? So that's if it's a material change, if it's something severe, that's why if you're saying the case has already been approved, so just assume it is okay. They're administering something that is different. Now you are concerned about this, so to help you sleep better at night, you can prepare for plan B if the case gets revoked and denied. But it might not happen, right? Half of the evils that in life never happen. We just worry about it. So just to help you sleep better, these are the paths of what you can do now.
What are the home or work visits? What cases can USCIS do that to, and which ones can they do it, but it's very uncommon?
The most common that we see, H visas, L visas, marriage cases, VAWA cases. These are the ones that, asylum cases, obviously. These are the ones that are on the political radar. These are the ones that USCIS always talks about. These are ones we've seen over and over and over and over again. H visas, L visas, F1 schools, but that's kind of different from you. R visas, religious visas, it's a mandatory one, right? So, and then marriage cases and VAWA cases. So those are, again, these are ones that if you file these case categories, you should definitely prepare for it. Other case categories, you should be aware of it. You should, safeguard against it. But, I've seen less of those.
Okay, so I want to go back to that DS question we got at the very beginning.
Oh, yeah, that's right. Okay, I promised our listener that our viewer that we're gonna get.
Yeah, you said the full back half would be about DS.
Yeah.
I don't know if we can keep that promise,
Yeah.
but
Let's do it. Okay. I heard that within the next few days, let's just give them a week, that this final rule will be released. It is extremely concerning because we don't know what the final rule is going to look like, but there's a high chance the original status will be canceled, and now every single student who adjusts status, every single student who graduates, once their I-20 expires, their I-94 is no longer duration of status, and it will be at the end point of their studies. And now, if they want to continue to study, if they're in the United States, they will have to file a change of status with USCIS. In the past, that didn't have to happen, but now they have to. Or they go back to their home country and they get a new visa and come in again. A lot of people choose not to do that because they think the chance of denial is much higher in a foreign country. So USCIS takes on that burden. However, why is this so concerning? Is because when you are a student, 4 years, 6 years, 8 years, a lot of times people have to stay a lot longer than they expected. You thought you were just going to come here for high school, then you want college. After college, you try to get a job, you couldn't get H1B selected, you couldn't get the OPT, you need grad school. Once grad school wasn't far enough, you had to do second grad school, you had to do a third grad school. You're not married yet, and so you have to just keep on staying. We've seen some PhD students and double masters just continue to study and use their CPT to make a small medium living to maintain their status in the United States, even though they are EB1 already about approved. Why is this concerning? Because in the past, when you continue to study, when you stay on division status, the school maintains your record, and it's the DSOs, and the DSOs don't check that much, and so it is relatively easy to stay in status. But once people have to file with USCIS, the way USCIS officers are trained, plus the AI system that they use, one day of unlawful work, one paycheck that wasn't correct, your CPT expired, and then you got a paycheck right afterwards. You might have worked one day. Sorry, you violated your status. Sorry, your status is revoked. Sorry, you need to leave the country. And I'm saying sorry really politely because they don't say sorry. They just directly say your status was revoked, status terminated, you need to leave. And so a lot of reinstatements will probably need to file. A lot of visas will need to be reissued at the consulates, and it becomes really difficult. And so H-1B becomes much more important. Securing your OPT becomes much more important. Maintaining your OPT becomes much more important. Filing a great change of status application becomes much more important. And how do you file a great motion, change of status? Going from undergrad to graduate might be pretty easy, but going from graduate to the next graduate program becomes significantly harder. And going to day one CPT schools, not high ranked. I mean, let's say you went to a good Ivy League, or let's say you went to a top ranked university, and suddenly you're changing to study something completely different from your field in a low ranking school. USCIS might not buy that. And so that's going to have a big impact on a lot of educational institutions in the United States when students no longer trust the change of status with their organizations or die 20 for those organizations. Tourist visas coming in and changing to student visas might become a lot more difficult. It is already much more difficult now, but much more difficult later on. So there's all of these things that's all going to happen in the next few days. AI, with the F1 duration of change of status, with the new memo on everything being discretion, change of status being a discretion, adjustment of status being a discretion, H-1B, even with the lawsuit, uncertainty prevails in the H-1B space. So are you going to be able to be selected? Are you going to do a self-petition instead to be more secure? All of these things become a big question mark, right? And so the demand to understand your immigration status becomes that much more important, and the strategy becomes that much more important. And again, in the past, F1 international students come here, change schools, they could buy themselves so much time, and then get married, and then get a green card. That pathway might be closing within days. That's the news I want to share. There's a lot more that's going to come out. Right now, a lot of speculation, but once it comes out, we're definitely going to be doing an in-depth live and a lot of video segments talking about this. We're going to talk about F1 reinstatements and how to do it well. We're going to talk about change status and how to do it well. We're going to talk about all of these things. And so if you're a student or if you're about to graduate or you're in OPT and you're thinking about going back to school, all of these will impact you.
And would that be effective like right after publication?
Right after publication, within 30 days, then it becomes final, and then it will be implemented, and then USCIS will issue memos and guidelines on what it means, right? So the policy rule will come out, but what does it mean? How is it going to be adjudicated? What are the factors to look into? What are the positive or are the negative? Those will come out from USCIS in the months to come, but the implementation of it will become immediate. Meaning, once it gets adjudicated, once the 30-day pass, once it becomes final, then following that immediately, when customs interviews the next set of international students coming in with their F1 visas, when they get that stamp, it is no longer going to be the DS. It's going to be just like everybody else. Your authorized stay, your I-94, is to a certain date. And so now, if you want to change status, if you want to change to a different school, 539 preparation will go in place. And if you don't have the guidelines yet, you can only do your best to anticipate and file accordingly.
If a green card holder lives out of the U.S. for 7 years and applies for citizenship, what would happen?
If you have an N470 approved, there is a small chance that that can still work. If you work for the military, that can still work. If you don't have N470 and you don't have citizenship, that is nearly impossible. I don't want to say it's absolutely impossible, but it is nearly impossible because you break so many of the fundamental rules. But I could see USCIS adjudicating and making an exception. Basically, they will annotate you could have gotten an N470, you didn't, but they're applying it retroactively. I've seen that, I don't know, I think a decade, right? But it is in this administration now, it is extremely rare.
What do you think will happen with the annual asylum fees? Will they last, or will the lawsuit eliminate?
We don't know. I don't know. I don't know because we don't do asylum cases, so I don't have a good insight into what the future looks like for asylum cases.
Is it even a good time to start the I-130 or 601 process for a spouse, or should you just wait it out?
Chinese proverb: the best time to plant a tree was 20 years ago. The next best time is now. I-130 takes a long time. It's not going to look any faster later on. The moment you start, it gets a process. 601, you could start it, you could build on it, you might get a request for evidence 2 years from now. You could build up and prepare for that request for evidence, right? So if it's things that's going to take a long time anyways, might as well start it. And just because you filed the case doesn't mean your work is over. The immigration journey goes on decades. I-130, the National Visa Center, the consulate, conditional green card, the permanent green card renewal. There's so many steps to prepare for. So if you don't even start, you'll never get to the finish line.
And how often do you go live?
We
Normally.
at the conference, we're doing it every day. So we're doing it today on Friday. We're gonna do it again tomorrow. But normally,
12 p.m. 11. Oh yeah.
well, I don't know.
Yeah. 11 a.m.
Either 11 or 12, but probably 11 tomorrow. But we normally do it every Thursday at noon on YouTube, on TikTok, and I think on Instagram.
On occasion.
And we're gonna roll it into soon eventually. But every Thursday at noon. But if you missed the live, don't worry about it. We post a live on our YouTube channel, and if you ask us questions, Galen will do his best to keep it, and he will ask it during the next live session, right? And so I'm here trying my best to try to help as many people as possible. Thank you guys for watching. Take care.
We still got a couple minutes.
All right.
Just a few. How do I contact you, and where is your office located?
Most of our consultations we can do online, but our office is based in Artesia, Cerritos area. It's in Southern California. You're welcome to book a consultation on our website. It's $250, and you could, if you book the consultation online and you only want to speak with me, then please put in the notes you only want to talk with Joseph. But we have a really great team, and everybody is better than me at what they do, right? So, for example, if you want to do adjustment status, interview prep and stuff, Gabby, so many other team members, they do so much more than I do. If you want to do EB1A visas, other people are doing like 10, 15, 20 cases at a time. I rarely touch them these days other than just kind of supervising. So whatever your case category, our team is able to help you, and they can do it much faster. But if you only want to talk to me, for whatever reason, happy to. Just put in the notes, and then we will reach back out to you to kind of arrange it.
Can you say a few things about denaturalization?
Yes.
The situation seems to be getting worse.
It is getting worse than I thought, but it is not as bad as what you see on on social media or online. Just to put things in context, right? Even if the government achieves what they stated out that they want to achieve, which is very unlikely, pushing 200 plus denaturalizing cases a month is crazy. I mean, historically, it's like multiple years is not even like 300. Now they're trying to do 200 a month, right? And so that will be extremely high. But with that being said, even if that is the case, they're pulling back the past 10, 20 years, and are oftentimes people with heavy convictions and things that are like major, serious. And some people are already out of the country. A lot of people are already incarcerated. A lot of people are high-profile cases that the government wants to attack, and there's like fraud rings that they've inspected. So the government has been collecting this data and working on it for years. If you recently be naturalized, if you have just years on your naturalization form that are relatively insignificant. If you contribute to the United States, well, if you have no conviction, these are not the things, and you shouldn't worry about it. So for the majority of the people, right? And again, to put it in context, even if they do 200 cases a month denaturalizing people, 300 cases a month denaturalizing people, you tally that up for a whole year. I don't know, is that the 1% of people naturalizing every single year? You know, so just to put it in context, not something that most people need to worry about.
Is it safe to apply for AOS at this time after the memo, or better to wait it out?
If you have a good case, still fine. That's what AILA speakers have been saying at this conference. I spoke on this topic Wednesday, teaching my fellow attorneys how we are doing it and how other law firms are doing it. And the encouragement is, if you have a good case, still do it as well. And if you have a bad case, and this makes it weaker, that is something you want to reconsider and prepare for a plan B. So that's the advice, right? So it is not what they say where like USCIS is completely stopping adjudication. We have seen a lot of cases still get approved, even waived, even as a tourist coming in and waived and still got the green card. So that is my encouragement to you. Really take a good look at your case, analyze it for its strength and weakness, get multiple opinions on it. And if you're worried, you can also have an attorney go with you to these interviews. So these are things to think about.
What's the difference between expunging a record and vacating a case?
There's a lot of differences in the state court, but for immigration purposes, because they're a federal law and they don't really care about state policies, if a case gets expunged to them, it's as if it didn't get expunged. They can still adjudicate it on their own as an immigration officer. And just for your reference, this is what an officer told me. Even if you've never been arrested or convicted, based on what you say and hearsay testimony, they can make a decision and rule as if you were convicted. That is the power of an immigration officer. They have essentially authority that exceeds even a state judge. Just to put things in context, right? So if you have a conviction in a state court and it gets expunged to an immigration officer, let me review it. Give me the police record. Give me the statute. Give me everything, and I will evaluate whether or not you are inadmissible and you are deportable. Now, if your case has been vacated, dropped, well, you still got arrested, still on your record, still on your FBI report, still on your DOJ report. Let me see what happened. Let me be the judge on whether or not you are inadmissible and deportable. So, for immigration purposes, pretty much the same thing. Vacate may be a little bit better than expunge because expunge means actual conviction, and then dismiss an interest of justice, whatever that means, to an immigration officer.
Okay, and the last question, my first wife's case was revoked. Is it a good idea to use the same USCIS account for my second wife's case?
Good question. No one has ever asked me that before. I don't think it matters in the sense that USCIS will see it no matter what. And therefore, it's almost suspicious if you create a new USCIS account, right? Because it's part of your A file. It's going to be there. So, for out of convenience, maybe just use it, but do a really good job explaining. Okay? See you guys tomorrow. Thank you for watching. Take care and have a great Viva World Tournament. Take care. Bye-bye.
Bye, everyone. World Tournament, huh?